Okay, this is Brockhouse versus United Parcel Service, Inc., docket number 07-152NZ. And this was the time set for hearing on the what's entitled Plaintiff's Motion to Vacate Arbitrator's Improper Opinion for Multiple Failures to Apply Controlling Law and Motion to Extend Brief Page Limit. And I'll just take your appearances for the record, please.
Good afternoon, Judge. Scott Combs for the plaintiff, Mr. Brockhouse.
And this is John Mullen on behalf of the defendant, United Parcel Service, Inc.
All right, thank you. I actually don't intend to hear argument on this or to rule on this today, but I wanted to call the case and address some issues, mostly because of my displeasure with the plaintiff's brief in this matter, and also the defendant's complaint also related to the brief and the way that it was received with the timing. So the plaintiff filed this motion, and I gave the title of the motion. It includes a motion to extend the brief page limit. I didn't have a say in the matter because there was no order submitted that would allow me to grant a page limit in excess of the 20 pages under the court rules. And the brief was filed without leave. It was just part of the motion, and the motion only says at the very end, request is made for extension of brief page limit due to the extensive testimony and exhibits. What was filed then was not only without leave in excess of the page limit, but I received a brief that I counted 58 pages long, although the pages are unnumbered, and it has 58 pages as being kind, because it has, for example, pages of deposition testimony inserted within the brief. So not only was I unhappy having received all of this a week ago, but the plaintiff was likewise unhappy, or the defendant, pardon me, and filed a response asking for an adjournment of the hearing for today, and then also went on to, in brief reply to the content of the plaintiff's motion in the event that the court was unwilling to adjourn. I have thought about what the proper way to go forward is on this, because the brief is so non-conforming in every way. And I decided that it really wouldn't be fair to the defendant to give the plaintiff another shot at it. So I'm going to accept the 58-page brief, and I am going to give the defendant a chance to more fully respond to the brief as they requested in their response, and I will give the defendant 21 days, somewhat akin to a motion for summary disposition, to file a response to the plaintiff's motion, and I will reserve ruling on the defendant's request for an award of its attorney fees and costs. And although the defendant in brief addressed some of the issues in their response, there was another issue that I would like to hear the plaintiff's position on, and that is the arbitration agreement, which has been called a confidential agreement to arbitrate, but it is in the court file, not sealed, available to the public, and it indicates among its many provisions that the plaintiff signed off on, and the defendant, the award shall be binding and conclusive upon the parties, and there will be no right to appeal or challenge the award absent fraud or corruption. So I would like the plaintiff, or the defendant, pardon me, to address that as well in a response. And that is all I have to say. Any questions?
Thank you, Your Honor. I think your directions are clear. I think 21 days from today would be July 22nd. And that's for me to submit a full responsive brief to the motion to vacate. And I think 20 pages is the page limit, which should be more than adequate. And just to address, so I can address and elaborate on the issues raised in my brief response I was able to file, but also address the arbitration agreement language that you just referred to. I'm happy to do that. And I think I can address all the issues that are before us. If there's anything else that would like me to specifically address, I'm happy to do that.
That was it, and there is no provision in the court rules for any further briefing from the plaintiff, so I'll just take your response, Mr. Mullen.
Thank you.
And I should add that I haven't decided yet, I need to see the response, but I may exercise my discretion to forego oral argument on the matter. But I would, again, reserve that for seeing everything as it's submitted. All right?
Understood. Thank you, Your Honor.
Thank you. That
Thank
will
you.
conclude our.
Thank you.